All right, this is the review course for Section 4 of the Certified Public Accountants Examination. You guys are looking awfully serious. So my name is Eric Pritchard. I'm an attorney. Don't hold it against me. I couldn't find an honest job. About 90% of my practice is in the electronic security, PERS, life safety industry. And I made two strategic errors. One was when I submitted the proposal to do this exam or this course, I didn't say to them I didn't want to be next to last program on the next to last day or the last day of the... So I hope you guys will stick with me on that. And secondly, last year I did a program on acquisitions, and they gave us 45 minutes and they put 2 more people on the panel. So 15 minutes content is no big deal. This year they give you, after you volunteer to do it and submit your submission, they tell you how long they have. This year they give us 75 minutes to do this program. Now, I always end up filling the time, but I'm not guarantee you this time that I'm going to fill the time. That's a lot of time, okay? I will do my best. 75 minutes is a lot of time. I do have a lot of stuff to tell you. So, ringer alert, not your phones. But you should know that there are 2 lawyers in this room, so just be careful. In addition to me, John Kohlhauer and Ernie. Yeah? No lawyer jokes? We're going to get to that right now, sir. Thank you. That's exactly where I was going with it. So what do you call 1,000 dead lawyers at the bottom of the sea? Good start. I can't tell that one. There's women in the room.
They don't care. You don't need that. You have their...
No. I'll tell you afterwards. It's a good one. What's the difference between a lawyer and a rooster? Anybody know? A rooster clucks defiance. Got it? Got it? Yeah. All right. So much for my lawyer jokes. So I got to do this housekeeping. Okay, please turn off cell phones or to silent mode. You should have received an evaluation form on your way into the class. Please ensure that you complete and return it. If you give me all the highest marks, you can come up afterwards and collect your $5 bill. If you're interested in obtaining NTS CEU credits, please check with the room monitor for the certificate of completion before conclusion of the course. So now I've discharged my obligations. All right, so... technology and the law. This is my disclaimer. I usually ask people to sign a release, but I decided not to do that this time. So this is not intended as legal advice. Consult an attorney, preferably me. All right, there's my disclaimer. Okay, so I got started in this industry 1994-ish, 1994. And I started as a young lawyer defending alarm companies and liability lawsuits. That's how I got started doing this. So they would be cases where there would be a fire, and the fire system failed to detect the fire, and there would be a loss. And we would get appointed by the insurance company that insured the alarm company, and we would defend the alarm company. Or there'd be a burglary of some sort, and the intrusion alarm didn't work, or it did work, and Central Station, somehow screwed up the dispatch. I had a couple of those cases in my day. But what I used to do was defend alarm companies. And back in 94-ish, that time period when I got started, we were using POTS lines. And anything other than POTS lines, if you had something other than POTS lines, it would probably be something esoteric like a McCullough loop, which was pre-POTS lines. And when we're dealing with the contract, which is really the best way to defend an alarm company is on the contract, we're dealing with, those NCR type paper, 8.5 by 14 triplicate or quadruplicate forms that people use in this industry. So that was kind of how I got started in this industry. All right. 20 years later, almost 20 years later, my practice has changed very dramatically, in the sense that increasingly I'm doing much less work on POTS lines and issues regarding old technology and much more work with new technology. So mobile applications, electronic contracts. We're not putting alarms on POTS lines anymore. So that's what we're going to talk about today. That's where we're going with all this. And I'd like to try to give you sort of a survey, if you will, about what I think some of the big legal issues are in the industry that are changing based upon the technology. I love questions. Feel free to interrupt me. If I'm going to deal with your question later on, if I plan to deal with it later on, I'll probably just ask you to wait. And if not, we'll deal with it right then and there. I also like input, and I also like conversation. And like I said, we got 75 minutes. So if you guys want to talk about something amongst yourself, because there's a topic that you want to share on or ask questions about, I'm happy to do that as well. Okay? All right. So let me tell you what we're going to talk about, and those of you who aren't interested can get up and leave. So I want to talk about contracts. There are some new territories in subscriber contracts in our industry. I'd like to walk you through what I think they are and walk you through some of the advantages and disadvantages of doing business that way and give you some rules of the road. Okay? Second, I'm going to do a legal primer on the law of video, which isn't video verification. I'll get to that in a second. But video, installing video, monitoring video, using video in connection with your alarm system. I'll talk a little bit about the law on video. Third, I want to talk to you about video verification. That's where we're using video cameras to verify an alarm. Okay? And what's going on in the marketplace right now, and I can give you a little bit of the inside scoop based upon what I've been privy to be part of. Then I'm going to talk to you about mobile apps. And I'm going to tell you that I think apps are the wave of the future, and I think you're going to need them for your alarms. I think the cable companies and the phone companies that are getting into this business are going to push and drive some of that. And I'm betting you there's nobody in this room who has an app, maybe there is, that isn't a manufacturer's app, and I'm going to urge you to try to develop one for use with your system and talk to you a little bit about what that would look like in terms of the law regarding mobile apps. Then we're going to talk about privacy policies. They're increasingly important, and frankly, you need to have one. If you don't, you're making a big mistake. And then finally, I want to talk to you a little bit about cloud computing, because more and more of the security services that are being provided from the cloud, and there's some issues that you need to consider. Okay?
Do you have a boilerplate privacy policy?
I do. I sell them. Yeah. Just like an alarm contract. All right, so that's where we're headed. Okay, so let's step back a second and just do a quick sort of reminder on why we're using contracts in this industry and why it's important, okay? So the first thing is you want to memorialize the terms of your agreement, and you want to assist in the enforcement of those terms. What service are you providing exactly? How much are you going to get paid? What's your recurring monthly revenue? Okay? What happens under certain circumstances? The subscriber defaults, or maybe you default. What happens under those circumstances? Secondly, you want to limit liability and create legal defenses. So when I was defending alarm companies in litigation lawsuits, my number one defense was going to end up coming from the contract, almost always. And in that contract, we'll talk a little bit about this later, in that contract I would look to have a limitation of liability clause, an exculpatory clause, an indemnity clause, a waiver of subrogation, a contractual limitations of action clause, and I would try to use those clauses to get out of that lawsuit. And if I couldn't get out clean, I would try to use those clauses to leverage a good settlement for my client. And they're extraordinarily important. Contracts in those terms really work when you're defending an alarm company. If I can't defend you in court based on the contract, and I need to go in front of a jury, and there's a fire loss with dead folk, and I've had those cases, or there's a major burglary where the system didn't work, or the monitoring facility operator or central station operator didn't do their job, it's a tough case to defend in front of a jury, because the jury's going to have an expectation that this thing should have worked. And what my first line of defense is, and frankly my best line of defense, was always on the paper, on the contract, because I knew that I could convince a judge to let me out based on the contract, because those provisions are enforceable, particularly as between commercial parties. All right? 3, cash is very important in our industry. It's important because there's an upfront investment in buying, designing, installing the system before you get your RMR. So a lot of players in this space borrow against the recurring monthly revenue. And the lenders in this space want you to have a contract, and they want you to have a good contract. So if you're going to use your existing accounts to borrow, it's another reason why you want to have a good contract. 4th, to ensure best insurance rates. So all of the programs in this industry are underwritten based on the enforceability of the contract. And what I'll tell you is those contracts are enforceable in most circumstances. The only time they're really not enforceable is, 1, if the subscriber can make out a claim that the contract isn't enforceable. What would that look like? Well, it's a residential contract and you forgot to get a rescission cancellation notice, 3-day cancellation under the FTC. Everybody familiar with that rule? Under the Federal Trade Commission, it's called the Door-to-Door Sales Act. There's a cooling off period of 3 days. If you take that contract to do any bit of the work at home, you have to get that thing signed. And if you don't, then under federal law, which applies to every state, the contract is voidable by the subscriber. Okay? And I'm not so much worried about the contract, the subscriber voiding the contract based upon the payment of RMR. Small collection matter, I'm not really concerned about that. But what I am concerned about is if there's a loss, and the lawyer who represents the plaintiff, either the insurance company, the subscriber, or both, understands the law, they're going to set that contract aside, which you don't want. And in some circumstances, it plays into your insurance, because if you don't have an enforceable contract, you may not have coverage under your insurance policy. You got to check your insurance policy very carefully, because a lot of insurers will include a provision in their insurance policy that says, we will provide coverage provided you have and enforce what they call liquidated damages clause, which is really what I would call a limitation of liability clause, but it's a clause that limits your liability to X dollars, okay? And if you don't have a contract and then you find out you don't have insurance, well, you got big trouble. Your next step is bankruptcy court, frankly. So that's another reason you want to have your contract. Also, if you've got an accepted contract, you're going to get better rates on your underwriting. And, yes, sir?
So we're a proprietary monitoring station. How important are contracts for proprietary, or when am I monitoring my own facilities?
Yeah, so I think you're okay, but I think what you're telling me is that your monitoring client is you.
Yes, we monitor our facilities that are
Yeah, I can't imagine why you would need a contract under those circumstances. Yeah, you're going to still stay, though. You're not leaving, are you? Okay. All right, and then the 5th reason is to position the company for sale. Okay, one of the beauties of this industry is that if you amass a significant amount of recurring monthly revenue, you can sell it. There's a very active secondary buy-sell market for buying and selling these contracts. And you can make a very nice multiple and a very nice profit if you've got a good company and you've got a good contract and a well-run company with a good subscriber base. Okay? So those are the reasons. And by the way, I love deals. And if you want to talk about deals, my 445 talks about deals. And I really didn't know that that was the last one of the day. Maybe we'll serve cocktails there. All right, types of contracts. So when I got started, really everybody did everything in this industry based on wet ink, which is you took the form to the subscriber and you had them sign in a ballpoint pen. That's a wet ink signature. That was really the contract that everybody used back in those days. Today, I'm seeing more and more types of contracts in the industry, okay? So one is a shrink wrap contract. Now, anybody in here who's ever bought software has entered into a shrink wrap contract. Because when you buy the software, or you buy a computer with software and you load it on, when you get the software, it's in one of those shrink wraps. And you open it up, and there's something in there that says, by using this and by opening it up, you've assented to our terms and conditions. That's a shrink wrap contract, okay? So that's something that I'm seeing increasingly in our industry. Now, I'm not seeing it in the mainline sort of alarm company, But where I am seeing it is in the DIY space, do it yourself, with the companies that are shipping out equipment and having the subscriber plug it in themselves and then have it monitored. And I also see it increasingly in the PERS space. So those contracts are enforceable. I do see them. It is a way to go for some players in this industry. The next form of contract that I see now that I didn't see years ago is the click-through contract, which is another contract that everybody in this room has entered into because we all have Google accounts, Gmail accounts, AOL accounts. We sign up for this, that, or the other thing. And really what you're doing is you're clicking that icon, I accept, you're checking the box, I accept, you're clicking OK. That's a click-through agreement, okay? Those as well are enforceable. And I do see players in the industry beginning to move away from original, from wet ink paperwork to click-through. There are a couple things you need to know about doing that, and we'll talk about that in a little bit. The fourth contract that I've seen now in the industry is a phone confirmation of an online or paper contract. Does anybody use phone confirmation in this room? Okay, so you see these out of the big summer programs in particular, and what they are is at some point the subscriber has to call the call center and orally agree to those terms and conditions over the phone. And it happens in one of two ways. It's either a sort of a push button, if you agree, hit 1, if you don't, hit 2, sort of a thing, or it's a recording of the conversation. And that can be a legally binding way to enter into a contract. So those are what I'm seeing today. All right, wet ink paper contracts, we're talking about some of the pros and cons. Wet ink.
What about, electronic signatures?
That's a click-through. Yeah. I'll get that under click-through. But you know what, I probably should have been a little more clear about that. It's a good point. Yes, sir, and you keep the recording. And there are companies out there that do that as a service. That's their business. But it does have to be recorded and it has to be preserved, because if I got to go to court 6 years from the time that you entered into that contract to protect you, that's how I'm going to prove up that the contract was agreed to. That's an important point. Okay. Paper, wedding signature, all right? We all know it, been around a million years. The insurers love it, the lenders love it, the buyers love it, okay? So if that's what your base is now, I'm not telling you to run out and recontract your base on some fancy electronic paper. That's not my point. But what really I think is going to end up driving us in this industry away from those pieces of paper are the consumers. And ultimately, I think that's okay, but we got to get the lenders and the insurers to buy in on that, and it's happening. So pros, it's easily enforced and it's most familiar right now for customers. That's going to change over time, I think. Customers are going to expect to assent to terms and conditions online more and more. Easily enforced if you have it, okay? Invariably, 1 out of 3 bad cases that I get, the contract was missing, the original contract is missing. You got to have policies and procedures in place for those original contracts. They got to be stored somewhere in some sort of organized manner, and they have to be protected in a fireproof box and maybe off-site at Iron Mountain or something like that, depending upon maybe perhaps what your lender requires or what your own policies are. Cons for the wet ink paper. So they require action. It's a little more work than a click-through. And you don't always have them. Sometimes you lose them. And the concept is that the computer's a better means to track. Shrink wrap doesn't require customer action. And the method could cover 100% of your customer base. If you want to move to shrink wrap, this is my disclaimer. Don't do this on your own. Don't do this at home. It's not, right now we're on a closed track. Don't drive fast by yourself. Get yourself a lawyer. If it's not me, get somebody else who knows what they're doing or has a big malpractice policy. Okay, shrink wrap. So there's no case law that we've been able to find on all fours, which is to say shrink wrap electronic security. There are shrink wrap contracts out there, okay, and they are enforced as long as you meet the requirements, but there are none that are in the security industry, so I just have to give you that note of caution. Some of the cons, there's an additional cost of printing notices because you're going to ship that box, you're going to have a big orange sign that says stop. Opening this box and using the equipment constitutes assent to our terms and conditions, that sort of thing. Then you're going to include something inside the box that's going to be your terms and conditions. And it's also going to probably have a warning sort of attached to it that says, by opening this box and using this equipment, you're agreeing to our terms and conditions. That's the essence of a shrink wrap, okay? Click through.
Can I go back to the shrink?
Yes.
So it would be a practical application of a normal alarm contract, or, you know, our salesman goes out, he sells it. How do we apply the shrink wrap concept?
I don't think you would. Where I see shrink wrap now is in the PERS industry a lot, and in the DIY industry. Yeah, but a lot of the DIY guys are pretty sophisticated and have you agree online beforehand. Yeah. Click-through contract. Pros, generally enforceable under state and federal law. Same for e-sign, for e-signature contracts.
Okay, that's one.
Yes, sir.
You said it could cover 100% of a customer base. Are you applying that comment that it could in the future? Or?
That if that's the way you did business, if that was your method of, yeah. Really what it comes from is, can you guys hear me all right? Is this working? Yeah. What it really comes from is really the PERS industry more, yeah. Web-based contract avoids printing and call center costs, call center to record that oral confirmation, printing to print the contracts out. You know what, I didn't like it on the left. Now I don't like it on the right. Let's try it on the tie. Let's see how that does. Better?
Are you going to provide us with these?
For a slight fee, it's $52, sir. No, absolutely. Anybody wants the slides? Anybody wants the slides? I'll email them to them. $52 Canadian. What's that?
Dean lawyer humor again.
Yeah. Well, I got to make a living. I got these kids at home. All right. Web-based contract avoids printing and call center costs. Electronic records less expensive than storing paper. Look, if you can get there, I think you should. I really do. If you can get to electronic and off the paper, I think you should. Again, lenders, insurers. Probably difficult to deal with buyers at this point, but definitely lenders and insurers. Can be set up as a condition to the initial order, a front-end contract. I like that a lot. In other words, you go online and you click through our T's and C's before I roll a truck, before I ship equipment, before I install. I like that a great deal. Or as a condition to equipment activation back-end contract, okay? And if you're going to do this, we need to work through the 3-day rescission issues, because there are 3-day rescission issues if you end up sending a truck to the premises to do an install, even if the contract is being entered into over online. And I can work through that issue with you if you're interested. Okay, familiar method for person making purchasing decision. Okay, we've all done it. We know it. And really, from my perspective, here's the sort of dirty little secret of contract formation. You know, I always get these conversations with people, you know, with you guys, about how long my contract is and how many words it's got and how small the type is, and do you really have to include all this stuff? Nobody reads on click-through. We all just check that box and say yes. So that's the beauty of click-through from a lawyer's perspective. All right? So if you can get there, do it. Now, it also can be an effective way for add-on services. Okay? And we'll talk a little bit more about that. But if you've got an existing paper agreement and you want to add some new services, maybe the way you do it is you drive the subscriber to your website to click through T's and C's, as opposed to having them sign a new piece of paper. Okay? That's much more efficient. We'll talk a little bit about the legalities of that, because there are a couple issues you have to consider. The cons of the click-through is, you know, you're going to have the customer to do something. Generational issue. Old folk like me might be more used to signing paper. And you got to make sure that you deal with authentication. Okay? And you got to figure out a way to deal with that. Maybe it's by email address, but you got to make sure that the person who clicked through is the right person. Okay? If the alarm is for one person, you don't want somebody else clicking through. They may or may not have authority to enter into that contract for the subscriber. Is there anybody in here who's using electronic contracts for subscribers? Yep. Ernie, how you finding it?
Pretty new in the game, but great.
Yeah.
Shameless plug, at 5 o'clock in this room, we're going to do a technology forum. That's one of the things we're going to show.
You guys have the iPad contract thing? Yeah. Yeah. If I wasn't busy, I'd stop by to see it. I'd like to see that.
If you see it, make sure you
Well, if we can get a retainer in place, maybe I'll cancel my 445. Yeah, I mean, I just think it's the way we're going. You should know there's technology out there where the salesperson takes the contract on their iPad and you either sign it or you authenticate it through the iPad with maybe a driver's license and that sort of thing. So it's there. We're there. And if we can get off that old paper, we'll save the earth. Yes, ma'am.
So if you do the click-through contract, right now we take our contracts and we save them, and the original contracts, we scan them in onto that person's account. So if you do the click-through contract, how do let's say someone says, I want to go back and review, can you send me a copy of the contract I signed? And let's say, since then I've changed the contract somewhat, how do I know, does it automatically generate a copy of it that I can then attach to the, do you understand what I'm asking?
Yes, it's an issue of record keeping.
Right.
I honestly don't know all of the ins and outs. There are companies in the industry that do this. Problem is they tend to be a little expensive. But you probably could manage this through one of those like e-sign type companies, or I can't think of the names. There are some less expensive document.
Right signature.
Yeah, right signature. E-original is another one I've seen. Yeah.
And most of the software will generate a PDF and email it to the customer and email it to the user records. So from the iPad, I assume this gentleman's software will do that too, that they'll generate a PDF or whatever.
If you have a line of credit as we do, or the industry banks, they're gonna want you to save it in electronic contract vault, where it's watermarked, we save a copy on our server, but it's watermarked copy. The authenticated original, as they call it, in the vault. We simply have that watermarked copy attached to all of our accounts and sit on the office. We can routinely run those customers.
Yeah, you're going to go through that issue with the lender. You guys use the guys in Baltimore?
The original.
Yeah. Is that who that is in Baltimore? Yeah. Yeah, they're a little, that's a little expensive service. So as much as I'd like to spend an hour talking about authoritative copies under the Uniform Commercial Code, you guys would fall asleep. But it's really, you need to have an authoritative copy, and it's new emerging law, and it's tricky, and you got to do it right. I just had a borrower move from, e-original to e-sign, or e-sign to e-original, and there's some issues you got to work through. But it's worth it because you're no longer storing paper. By the way, another way to get rid of the paper issue is to scan your paper contracts. But you got to make sure that you have the contractual right to do that. In other words, that your contract says, we can copy this and it will be deemed to be an original. And then you can throw away the paper original. All right?
If they've faxed in the original.
Well, then you better have language that says fax signature is deemed to be an original for all purposes. That sort of language. Yeah. Phone confirmation. Generally enforceable, can be fully automated, we talked about. Phone can be easy, can be set up as a condition to activation of the service. You see this more in the PERS and the DIY segment of our industry, where you're sending a unit or components, and they plug them in, and then they're going to call in to set up the monitoring. That's a way to do it. Cons, you still got to print paper because you got to send them in the box. There's some cost for automated system. You got to worry about the authentication issue, and you can't provide that 3-day rescission notice. Now, if you're not going to the premises, you're just shipping, you don't have to worry about the 3-day notice. All right? Okay, so that's contract. Sir?
What is your position on the cooling off period? How are you advising that they deliver an electronic copy of that if the person does not have an email? Because the law says you have to deliver 2 copies at the time of sale, right, with the sales agreement.
And the e-sign law says that anything that you have to deliver, you have to make provisions for in your e-sign document to give to them. So if they don't have an email address, I think you got trouble. I think you got problems, because that's the way that we advise clients to do it, is through email. Yeah.
We agree.
Who doesn't have an email address?
Have a paper contract.
Yeah, I'm sure they don't.
If they don't have an email address,
You can always do a paper contract.
Yeah. My 98-year-old grandmother doesn't have an email address, I don't think. All right, so I'm ready to move on from, yes, ma'am.
I just have a question either for you or anyone else. We're running into more and more trouble with commercial applications wanting us to accept their
agreement and not change the T's and C's or sign anything for it. Does anybody else have a problem with that?
Yeah, so I do a lot of that work, and I'll talk a little bit about it. Here's what it may not work. It may not work legally. If you get into a real Donnybrook and you got 8 lawyers looking at the paperwork, that may not work. It may work, but it may not. And I'm not crazy. I see a lot of that. You sign mine, I sign yours sort of thing. That's a nightmare too. By the way, that's better than, if you're going to take the work, that's better than not having any position, but it does create issues. Sometimes there's work you just don't want to do and you got to walk away from. And what really scares me for you is make sure your insurance policy doesn't require a liquidated damages or limitation of liability clause. And when I say make sure, I don't mean call the agent, because they're not going to know and they're going to tell you not to worry about it. And you can't rely on anything that's not in writing from the insurer or the agent. So you got to sit down with that policy yourself and go through it line by line. And invariably, at the end of the policy is that rider that says you got to have, as a condition of coverage, you have to have what they call liquidated damages provision, which it's really a limitation liability clause. So that would be my concern. Sometimes what you can do is come up with an alternative set of T's and C's. Sometimes what I do for my clients is I come up with the fallback position. The problem with doing that is I can give you a document that is the fallback position from your form, but you can't use it with the other party's form because the language is going to be different. It's going to create ambiguity, and you're going to have all kinds of problems. So, and the truth is, on the commercial side, the customers are becoming more sophisticated. But there are ways to limit your liability. So in that instance, if you're dead set on accepting that PO, maybe what you do is you try to limit your liability to your insurance coverage. That's one of the ways I try to deal with it. So that at least the company's assets aren't at risk. Okay? All right. I'm ready to move on from contracts to video. Anybody have any contracts questions? Okay. Video. Okay. I love video. I love it all day long. You should sell the heck out of it. If you're going to sell it, though, make sure you got RMR attached to it, please. You got to have RMR attached to it. That's the only way it makes sense. Be it lease, maintenance, monitoring, that sort of stuff. Okay? Love video. Here's what you need to know. So, before we get to my little chart there, another reason I love video is that I think we're kind of secondary actors. So you're gonna sell and install a video system for a subscriber. In my mind, the subscriber is the primary actor. They're going to tell you where the video is. They're going to be the people looking at the video, okay? They're the people who can use video for the wrong purpose. We're really just the installer, and we're kind of a secondary actor. Somebody would have to take an extra step to get to us under a legal theory, all right? Now, that don't work if you're installing, a video camera over a set of showers. Obviously you can't do that kind of stuff. That's an easy one to get at. But by and large, in my opinion, we got some protection on video. I think some people get nervous about it, and there's no need to. But you got to deal with the risk through contract. You got to make sure your contract deals with the risk of video. All right? And if you're using some other lawyer's contract, whose name I won't say, there are some around. That's from 1984, and it doesn't deal with video, well, you're not dealing with video in your contract. I mean, you could have some real problems. So part of what I preach is go home and read your contract and make sure that you really deal with video. And with all due respect, reach out to some lawyer somewhere and ask them, hey, does this contract deal with video? And hopefully they'll talk to you, and I'll talk to you, but I'll probably say to you, it's cheaper for you just to buy the new contract. But you got to have a lawyer look at it, because there's a lot of different issues with video that you got to deal with in the contract. So, primer, just a quick primer. The thing we're really worried about with video is invasion of privacy. That's really the big concern. So invasion of privacy is a common law tort. So there are different kinds of law. Statutory law, everybody knows what a statute is. There's common law. Common law is judge-made law. It comes out of the English system of jurisprudence that our forefathers adopted in Philadelphia, a few blocks from my office, in 1776. But judges make law through issuing opinions, and that's how the law of invasion of privacy has developed over the years. There's also a tort called invasion of a secluded place or privacy. And you should know that invasion includes video and audio intrusion. Say that 10 times fast. Video and audio. So we're not only talking about video, we're talking about audio. Okay? Very quick primer on audio. Two kinds of states in our union. There's a single consent state and an all-party consent state. Okay? If you're in a single consent state to record audio, you need one person's consent to record it. It could be your central station operator. If you're in a dual-party consent state, you're supposed to get everybody's consent to record it, okay? So I just learned about this morning from another lawyer in the industry. Anybody here from California? What a wacky state, California. God bless them. So BMW has this thing called, it's like an OnStar type service. I forget what it's called. And BMW got sued, I think, in a class action in California, because when people were using that system, it's a wireless to a call center, they didn't get consent. They didn't get written consent to record that. So that's a new California case. The concern is that if you're in a single consent state like Utah or Pennsylvania, where I'm from, and your caller's from California or you're calling into California, how you deal with that, because clearly the California courts have said, our law is all-party consent, and you got to follow our law no matter where that phone call is originated to or from, okay? So that's something you need to think through. Another thing you need to know is that covert audio with video, tiny microphones on video cameras, absolutely illegal under federal law, okay? A criminal law, not a civil law. So don't do it, because you can get in big trouble. Covert audio in a video with a video camera is illegal under the federal wiretapping statute.
How do you define covert?
If you're not putting big signs around that we're recording audio. That's how I would record it, but I'm a lawyer.
In every language under the sun and Braille too.
Exactly. You're right. And in California, you probably want to take out a
You're talking
billboard.
about public spaces or private?
Any space. So there's a specific federal statute under the wiretapping law that says you cannot record video and audio with the audio being covert. So the news about, I don't think anybody does, I don't think a lot of people do this. I don't think it gets done, but probably 7, 8, 9 years ago, there was a very big raid in North Jersey, New York City, on one of the companies that sold cameras that had this covert microphone. The feds came in and raided them and shut them down, and people, got in real trouble. So that's how I know about it. But really, the key is that if you've got a camera, you can't have a microphone on the camera. You really can't.
It's pretty common.
I know. You go on the internet and you can find it everywhere. My advice to you is to stay out of that stuff. Yeah. Ma'am?
Can you do it as long as you have signs?
Well, maybe.
Even a lot of the major manufacturers have microphones in their cameras. It's not just a, obscure internet thing.
So when I was preparing for this, I went online and I found a whole bunch of them, but I'm telling you, that's the law. And you got to be careful.
So if you're not recording, if you're just viewing, it's okay?
I think so, yes. Yeah, I think so. That would be okay.
So there's a question, again, proprietary, in our own space, even though public has access to it, would that still be applicable?
I think you want to get releases from your employees. I think you want to put that in as a term and condition of employment in your employee manual. You might want to post signs for visitors. I mean, if you're recording audio in different places, what state are you in?
Utah.
That's a single consent, so you need one-party consent in Utah, I'm pretty sure.
So that
You're probably okay.
federal law, not a state statute.
Oh, you're talking about, yes, you're talking about video and audio together? Yeah, that could be unlawful, very well could be unlawful. Yes, if you email me or see me afterwards, we'll figure out how to get it to you.
I got a leave early to catch a plane.
I don't have a business card handy. We'll get you something. We'll figure something out. Okay, so, all right, so invasion of privacy, invasion of secluded places, The key issue is, does the plaintiff have a reasonable expectation of privacy? A reasonable expectation of privacy. You'd be surprised at some of the cases and how they come out. A lot of them are news cases, news reporters, not a lot of security companies, sometimes a guard company or a private detective, but most of it's news. But here's what I can tell you. Bedrooms, bathrooms, locker rooms, doctors' offices, all off limits. Really is. All off limits. Don't get involved in that. The invasion has to be of an objectionable nature, so it's not only a reasonable expectation of privacy, but the plaintiff has to prove the invasion was objectionable, and it's an invasion of private affairs. And there are a couple cases that deal with that. And I don't remember what those cases say exactly, but if you want the citations, there they are. You probably can find them.
What does it mean for the invasion to be of objectionable nature?
That a jury of your peers would sit and determine whether or not it was objectionable. That's honestly what it means. Yeah. The federal wiretapping statute, there's Title III, there's the Electronic Communications Privacy Act. They both apply to video and audio and transmission of video and audio. And basically the law is that you can't be using video unless you have consent. You cannot be looking into people's homes, looking into people's computers. That's what the Lower Merion case was a school district that was using those cameras on, gave student laptops. The laptop had a camera, and then the school district, some people at the school district decided they were going to view through the camera of the laptop the student. And there was a big brouhaha in Philadelphia, Lower Merion's in the suburbs of Philadelphia, so there's a very big lawsuit on that case. But the bottom line is that you can't be looking at video feeds unless you have somebody's consent. All right?
Say technician goes out to, or they call technician, restaurant, having problems with camera, you log in, IP, they give IP.
Yes.
He's looking at it on his whatever.
Yes. I think that's okay. What I think isn't okay is he's on for an hour and he's looking at a pretty girl, that kind of stuff. There was a case coming out of Atlantic City a couple of years ago where the guy in the security center was using his Zoom camera to zoom in on the cocktail waitresses in specific areas. And that was a violation of the law. You can't do that sort of stuff. So you just really got to use common sense here. You really, you just got to behave smartly.
In offices, do you need consent? Like, let's say you've got a call center, collections office, and you want to have cameras in there to make sure that it's the right software, enough Facebook and that type of thing.
Yeah.
To monitor, especially after hours and weekends when you don't have as much supervision on site.
So I'm a lawyer. I like as much consent as I can possibly get. So if we're talking employees, absolutely should be in the work rules and regs in the employee handbook. If you can get it signed by them, that's great. Or maybe you can get a signed acknowledgement that they've received and read the rules and regs, but I'd absolutely put it in there. I would absolutely want it.
So if we put a bunch of cameras in McDonald's restaurants or something, whose responsibility is it to get the consent? Is that McDonald's?
Theirs. That goes back to they're the primary actor, you're the secondary actor.
Contract that we would give to McDonald's, you'll exempt us from.
In my contract, I'll say you'll use the video for lawful purposes, and if you don't, you'll indemnify us for that. Yeah, yeah.
So anytime we're putting it in for something, whether it's residential or commercial, as long as our video contract excludes illegal uses, we're off the hook.
It's a start. It's a start, yeah. No, their lawyers are very creative. We talked about state wiretapping statutes, so I think we're good there. Okay. Boy, I'm going to fill this time, aren't I? Video verification. Okay, so this is kind of a bit of a hot potato right now, hot topic in the industry. A lot of hubbub in the trade groups, some new trade groups focused on video verification. So the concept is, verifying an alarm, using video to verify an alarm. So the first question I ask about video verification is how we got here. So from my perspective, 10 years ago, 12 years ago, I started reading Security Systems News because that's what I read back then. I now read SD&I because I write for them, security dealer and integrator. I read Security Systems News. The story was alarm verification non-response. I mean, 99% of the alarms were false, and police were tired of rolling, and cities were looking to save money, and they were cutting back on their dispatches. So what I think is pushing us into video verification, first instance, is alarm verification and the need for alarm verification, okay? The second thing I think is pushing us towards video verification is the availability of the technology. The technology is getting better, it's getting smaller, and it's getting cheaper, much more important, it's getting cheaper. You know, I talked with a couple of video manufacturers this morning, and they're making increasing strides in how they manufacture and what the price point is and how they can sell it. I think insurance also is another reason why video verification is sort of a wave of the future. So the insurance folks are very focused on deterrence. And you think to yourself, well, of course they are, Pritchard. What the hell do you think they're focused on? But let me give you some background. You know, the rule was, when I was doing insurance defense work, and I was surprised to learn this, but the rule was that an insurance company made $1 a premium, they were okay as long as they didn't pay out more than $1 on claims. So all their premium dollars could be paid out in claims. And you think to yourself, well, wait a minute, aren't they going to go broke? But no, the answer is they got very good at investing and made a lot of money off our premium dollars. That's how they made their living, and they could afford to pay out that claim. So in an up stock market, claims became less important because insurance companies were making a lot of money, okay? Well, in this economic, by the way, the market was down 300 points today. In this economic day and age, there's some concern about the one-to-one ratio and whether or not that's working. And I can tell you that insurers are looking at video as a way to deter break-ins, burglaries, okay? Property damage. It's a focus on property damage primarily, all right? And they're focused on it because the one-to-one ratio is not working quite as well for them anymore, all right? And they're focused on it because they know what the police want. Anybody ever ride along with the police, do a police ride along? Okay? You're in a car with the police ride along. I just did one.
Voluntarily.
Involuntarily, sir? Yeah.
346.
Yeah, what do I got till? What time am I done?
What's that?
3:40.
Saying market was down 300.
3:46? That you're telling me to get going. What the police really want is they want to know they can catch someone. That's what the police are in the business of doing. It's what they like to do. So if you can verify an alarm through video and tell them, two guys in the back, black clothing, whatever it is you're going to say to them, the police respond to that much more quickly. So it's an opportunity to upsell, if you will, your system. Now the flip side is that there are a lot of players in the industry who are worried that video somehow makes their existing digital alarm systems obsolete. Okay? There's a tension going on in the industry right now among some of the bigger players about where video belongs and how it's going to end up being used. I think we're marching towards video verification. I love video verification. I love it because you're offering your subscriber the state-of-the-art technology. You're probably going to use something that will give you some protection because it's a better system, so you have fewer claims. I love it because it's an opportunity to sell equipment, and I love it because it's an opportunity to sell RMR. And I love it because I think the subscriber base is increasingly expecting it. I think people really are expecting video on their alarm systems more and more. Now, I recognize that there are issues. There are issues about who can see in and whether or not the monitoring center folks should be able to get into the video feed. I get that in a private home. I understand that that's, we're not quite there yet. But I see video increasingly involved in the mix here, and I do more and more work with video players. So I love it. And there's a new industry trade group. I don't know if anybody's interested. You can see me afterward. It's called PPVAR, Partnership for Priority Video Alarm Response. And these guys are very focused on increasing the use of video in the industry, and they're just getting off ground, and I'm their lawyer, and I'm happy to put you in touch with them if you're interested. They're just getting started. They probably got, 100 members at this point. Okay, I did that without looking at it. Good. Sell more equipment, sell more services, both at a profit, further the value proposition. Consumers are expecting it. Meet the demand and assist law enforcement. Okay, that's why I love video. How do we stay here safely and profitably once we get the video verification? does your contract address video verification? If you're using so-and-so's form from 1989, it probably doesn't, all right? If you're using my form from 2013, it does. So make sure that your form deals with it. Can you drive subscribers to your website? So one of the things that I want to urge people to do who are adding video to an existing security system or even selling a new security system, let's try to drive subscribers to the web to agree to terms and conditions if we can do that, okay? One of the things you need to be sensitive about, though, is for an existing subscriber with an existing contract where you're obligated to provide video, okay? You may not be able to enter into a new contract with that customer unless you take certain specific steps, okay? Because there's a rule called the existing duty rule in the law, which basically says that if you and I are in a contract and I agree to provide A, okay, video in this case, I can't then unilaterally impose additional terms and conditions because we've already agreed to terms and conditions in our contract. So I can't then force you into a new contract downstream with new terms and conditions. So my concern is where an alarm company has an existing contract with a subscriber, adds a video or video verification or any other service for that matter, and then tries to drive the subscriber to new T's and C's on the web to click through or to e-sign, that agreement may not be enforceable as a matter of law. Okay?
What about wet signature on that?
Signature's not the problem. The problem is that you and I have a contract. I've agreed to give you A, all right? Now I'm saying to you, I'll give you A, but you got to sign a brand new contract. That new contract's probably not enforceable because this contract is enforceable. There are ways around that, okay? There are a bunch of ways around that, and I'm happy to try to help you deal with that. But it's an issue that you need to be aware of.
Would just be an addendum that speaks specifically to video?
No, it's not an issue of the paperwork or the signature. It's a matter of law. Basically, the law says you already have an agreement, okay? So you can't now impose a new agreement. I'm obligated to perform under that agreement.
Can you have simultaneous agreements?
Yes, you could. Yep, you could. Yeah.
Confused, so what about if an alarm company has a bad contract and we're gonna buy their company? We say, okay, go re-sign all your accounts on new paper.
Mm-hmm.
You saying that they can't go re-sign it because they already have a contract?
Different situation because now you've brought C into the picture, A, B, and C as the parties. Meaning the buyer is now offering to contract with the seller's subscriber.
No, I'm sorry, we're asking the seller, go back, recontract with your subscribers, and then we'll buy your company.
That might be an issue. It depends on how you do it. Depends on how you do it. So what I do in that situation is, and I think it's an easy give, you have to have, that one's an issue of consideration, quid pro quo, in your scenario. It's the existing duty rule, but the objection is, you're already, what's the added consideration? What's my new benefit for signing the new contract? I'm already in contract with you, okay? The way I deal with that issue is I give the subscriber something, and it's usually the following. I will agree not to raise your RMR for the number of months that you agree the term of the contract is, 12, 24, 36, which I think is a pretty nifty way to get around that, yeah. If your RMR is high enough, you know, if you're buying someone whose RMR is high enough. But you have to give consideration. You could do that too. I think that works fine too. But I hate giving up that money.
Sorry to keep harping on this.
It's all right.
We have some salespeople who like to recontract.
Uh-huh.
New commission for us, so you're 5 years up now, it renews itself automatically. So they go out after 10 years and say, oh, yeah, the contract from 10 years ago, we'll recontract. Is that okay?
If you get into a Donnybrook and the lawyer on the other side understands this legal rule, you could have no contract. That may not be enforceable.
We're already in contract with them, there's really no value to recontract. We think like, oh, then we're, locking in for another 5 years and just go out and do it.
Well, not if your contract renews automatically for successive periods. Yeah.
In some cases, they're renewing at a lower rate.
Well, that would be consideration.
That'd be your.
Yeah, I think that's okay. Right, no, I wouldn't either.
So if I want to add video to an existing customer, how do I get video T's and C's?
You don't expect me to give up everything, are you? You enter into a new contract, but you just got to make sure that you do it the right way. It's completely doable. You just got to make sure that you've documented it the right way, and probably an addendum is a way to go for a paper contract. A click-through, if you can get it, might be a way to go too, but you just got to work through the technicalities of it. Yeah. Well, it might if it covers video, but if it doesn't, then frankly, in that context, if it doesn't, I'd rather it not, because now I have a brand new agreement covering video. That I'm okay with. But if you're under some obligation to provide services, okay, and now you're trying to impose new terms and conditions, it may not be enforceable. The way around it is that you're selling a new service for a new price, all right, and you can get there. It's just something that you have to be sensitive to, and I'm happy to help you through it. Yes, sir.
We sell cellular systems, people who are got rid of their phone lines, and we're sending out a new contract for a cellular portion of it. Is that the additional service that you just said?
Yeah, as long as the contract that you've written with them doesn't require you or obligate you to sell cellular, I think you're okay there. As long as you're not under an obligation to do that. That's the key. Are you an under?
Originally, they declined cellular,
I think you're fine then.
and then we're adding cellular.
Yep, I think you're fine. All right, I'm going to move on because I want to get to all this other good stuff. Does anybody in this room have a mobile app other than a manufacturer's mobile app for security? All right, one person. He's the only one making money off this stuff. So, look, you all got smartphones, you all got apps. It's a very hot way to go right now. So I'm going to kind of just walk you through a quick primer on apps. So here's what I'll tell you. At my law firm in Philadelphia, we've got the alarm group, but down the hallway we have the telecom group. And the telecom group basically buys cell towers. That's what those guys do. They buy cell towers. We buy alarm companies, they buy cell towers. They are through the roof busy. People are buying, selling, and putting in new cell towers faster than they're doing anything. Frankly, I'm thinking of going into the telecom group, but that's a separate discussion. But what you need to appreciate is the growth of mobile activity. So in 2011, in the U.S., the first time ever, the smartphone sales of smartphones surpassed PC sales, first time ever. So that's 2011. We're already talking 2 years ago. So we're all moving to our phones. In 2013, there were 320 million mobile subscribers, 110 million used smartphones, 55% used the mobile device to access the internet. I don't know what the other 45% were doing with their phones, but maybe they just didn't understand. In 2014, mobile web usage is predicted to overtake PC usage. So we're moving there, okay? We're absolutely moving there. Those trends are absolutely not likely to continue. They are going to continue. So my message is, let's not be late adopters, okay? And the beauty of apps is everybody's in that business. There are 500,000 apps on the App Store, 300,000 apps, whatever it is, and people are getting in that business and getting into it left and right. So what that says to me is twofold. One, you can get into it if you want to, if you see it as a way to sort of broaden your security offering. And two, there are a lot of people out there who are doing it already, so you might be able to joint venture with one of them to offer an app that works with your security system. What's an app? It's a software program for a targeted task on a mobile device. It's a targeted task on a mobile device, okay? OpenTable, MLB.com. I used to watch when my Phillies had a winning record. They don't anymore, so I've deleted it. Those sorts of things. It's a targeted task. You're providing a new platform for delivering services and information. The key to the apps is to leverage the mobile device. Camera, voice capabilities, telephone transmissions, GPS, Bluetooth, okay, mobile functionality. That's the key to the app, and somebody in this room needs to come up with some great apps that leverage that part of the phone for use in connection with their security system. Slow adoption limits security providers essential for us in this industry to monetize those apps. It's recurring revenue, and that's where the model's going. I know that there are a lot of free apps. I know there are a lot of 99-cent apps. I know there are 2.99-cent apps, but what I'm saying is increasingly people are moving to a recurring revenue model in the app world, and it's a way to add to your RMR $7 a month, $10 a month for additional services in connection with your security system. App issues, area of concern, end user privacy, location-based services, intellectual property rights, advertising and promotions, and risk allocation. Location-based services. So if you're going to use an app with LBS or location-based services, which is the service that identifies where you are, there are certain concerns. You guys get that icon when the map wants to take you, that the app provider wants to locate where you are and you hit OK. That sort of concept, that's what I'm talking about. You have to have a mandatory disclosure. Now, I say mandatory, and I have to tell you that mandatory is just by the FTC, the Federal Trade Commission, because there really isn't law on this stuff yet, and it's suggested. That's not, I'm sorry, it's not suggested. The FTC wants it. You should do it, because the FTC is out there enforcing its rules. So if you got an app, you want to have mandatory disclosure of location-based services. I would think that's important in our world if we're going to do a security app that somehow is tied to your phone, sort of like, anybody familiar with Emergency? Anybody see that app? Emergency is one of them that's out there. I Am Safe is another one. There are a bunch of them. So if you're going to use a security app where part of it is using the phone to locate where your subscriber is for emergency situations, you got to deal with this location-based services. You got to say to them, look, we're going to use that to identify where you are, and if you don't agree to it, you can't use the app because we can't identify where the hell you are. You've got to get the mandatory consent, do that part of your contract. Security measures, you got to employ reasonable limitations on location-based information, and then you got to retain it only as long as you really need it. So if you are developing an app, they give rise to intellectual property rights. When I say IP, I mean intellectual property rights. Example of IP rights are the content. So the content in an app might be subject to copyright. All right? That's something that you want to look at if you're developing an app. Secondly is the app developer may treat the source code as a trade secret. Your source code probably is a trade secret. There's specific steps you need to take in order to enforce your rights as a trade secret. All right? Third is the name and terms may qualify for trademark protection with the Federal Trademark Office or even a state trademark. Okay? You need to think that through. And then the process or method in the app may in fact be patentable. I have clients in this industry with apps and software whose apps or software are patented. Okay? And that's, of course, the highest level of protection. So those are the things that you need to think through if you're going to go home in your garage and start developing an app. You also need a good app lawyer. Don't forget about that one. IP rights. So you want to define and secure ownership through contracts. Okay? You want to use the work for hire provision in assignment of inventions. In other words, if you're going to enter into a contract with an employee to develop some software or an app, you want to make sure you have a work for hire provision which says the company owns the intellectual property, not the employee. And if you don't have that provision, you could have some real claims from employees about software or any form of IP. And you want to have an assignment of any inventions in your employment contract, independent contractor contract, whatever, joint venture contract, whatever you're using to develop that app or any intellectual property, you want to make sure that you've covered that. Otherwise, your employee might make a lot of money off you. When you're out working with apps and third parties, you want to get non-disclosure agreements, confidentiality agreements, NDAs, restricted use agreements before you disclose confidential information. One of the things I find people take the position or take the attitude of, well, it's just an NDA. All NDAs are not created equal. They really aren't. There are ways to write NDAs that, from one perspective, from the party who's given out the information versus the party who's receiving the information, there are certain basic things you need in an NDA. If you're using an NDA, don't just go online and get one, please. Check with somebody who really understands non-disclosure agreements and what it is you need. Otherwise, you may not be protecting yourself. There are third-party IP issues. You may want to incorporate third-party intellectual property. Okay, maybe you want to make it communicate with a panel. Maybe it's communicating with a Honeywell panel or some sort of panel. You need to figure out whether or not you have the right to do that. Is there a license that's required? You got to look at the license agreement that you have or the distributor agreement, see what your rights are. You may not have the right to do it. You may need to go get it. All right? And there are all kinds of limitations on rights. Advertising and promotions. An app is advertising. It really is. It's absolutely advertising. And you need to comply with the law. which is primarily the FTC law, but also state consumer protection if you're selling to consumers. And if you're sending commercial text messages, you got to comply with the Telephone Consumer Protection Act. There was ADT just, I think, settled a big robocalling case a couple weeks ago. I think it was the FTC who brought it against them on robocalling. So be careful, that can get expensive. Risk allocation in apps. The FTC is focused on the fact that we're on a smartphone and all of the terms and conditions you barely can read, and whether or not that stuff's so enforceable. My way around that is, if you're doing an app, is to drive the subscriber to a website and have them click on the website to agree to your app terms and conditions. I think that's the way that you deal with that. Risk allocation covered by other agreements. This gets back to that existing duty rule and whether or not your contract covers the liability. And is the risk allocation enforceable? You just got to make sure that you've got a good risk allocation provision in your contract. For those of you who are still using limitation liability clause for $250, I urge you to get away from $250. That worked in 1964. I don't think it works in 2014. Okay, you want a much bigger number. I use $2,500. If you can get out of a lawsuit for $2,500, take it all. $2,500, take it all day long, because lawsuits are expensive and a pain in the butt. Privacy policies. So this thing started at 2:45. What time am I done? 2:15. What time am I done?
3:30.
Damn. All right. You got to have a privacy policy. You absolutely have to. You have to have one on your website. If you don't, you're in trouble. It's a mistake. What is it? It tells consumers how you collect, use, store, and disseminate data that you collect from them. You got to have one. When these started coming out, I think people took the position, well, we're not required by federal law to have one. You're required now by federal law to have one. Should be in writing, and it should be tailored to your business. One size doesn't fit all, which is code word for don't do this yourself, because you're going to miss something. You're going to absolutely make a mistake. My favorite contract copy mistake story is somebody who stole a contract from ADT and then went to sell their company. And when they stole the contract, rather than saying the contract is assignable, rather than saying the contract is assignable by the company, it said it's assignable by ADT. Yeah, the deal was over. The buyer walked away from the deal. So, you copy off the internet at your own risk, folks.
So you just need this on your website?
That troubles me, sir, when you say just.
Well, that's kind of,
You got to live by this.
you said put it on your website.
You got to put it on your website, and then you got to follow. You got to follow it. You got to follow it. Yeah,
Well,
yeah.
But
But
you don't have to post it like in every customer communication or...
no, but you might want to reference it. You might want to reference it on your website. You might want to reference it in. So, in specific response to your question, unlike some federal laws that require, like credit card companies will periodically mail you, here's our privacy policy, or insurance companies will do that. There's no specific federal requirement of that. Yes, yeah, but you got to abide by it. Why should you care? Because consumers are increasingly aware and care about this, and it can get damn expensive if you have a problem. So consumers are worried about hacking, identity theft, whether or not you're selling their information to third parties, including data brokers. There are data brokers out there that collect information, to pursue any kind of claim. I mean, you're all aware of this. If I send an email to my son that I like the new BMW 4 Series, which is a very sweet car coming out at the end of the summer, if I send that through my Gmail account to my son, which I did yesterday, you better believe that within a day or two at the most, BMW ads are going to start popping up all over my internet browser. I mean, so you got to be careful about how you're collecting information, what you're doing with it, how you store it. You also got to be sure that other people aren't taking data off of your website. There are companies out there that scour the web for other information, so you got to be careful about that too. Okay, types of information. There are different types of information. The one you need to really be worried about is personally identifiable information, which we deal with a lot in our industry because we have the address and the name of the subscriber. Personally identifiable information receives the highest protection under the law. So you have to be careful with how you're dealing with that, and you have to tell people in your privacy policy how you're dealing with it. There are other types of information. The FTC is primarily the company that's enforcing this, or the entity that's enforcing this. Their job is to regulate unfair and deceptive trade practices. They've filed 100 plus privacy actions in the past few years. The key to you is transparency to the consumer, privacy by design. What are you collecting? What are you doing with it? Do you use cookies? Who are you sharing with it? Why? Where's it being stored? How's it being stored? How long is it being stored before it's destroyed? You got to deal with this in your privacy policies. Common violations: collecting data without letting people know, failure to comply with your own privacy policy, and not having a privacy policy. Those are all legal violations.
Can you go over the first one, collecting without letting people know?
That you take their data and use it without telling them. I mean, that's absolutely illegal.
Sell it or use it within your business?
Either. Yeah, either. But you got to tell them. Privacy policy, tell them what you're doing. Another reason you should be concerned, increasingly this is getting regulated at the state level, state legislatures and attorney generals. Doing business means jurisdiction. I'm in Pennsylvania. If I'm doing a deal in California, if I got a subscriber, 100 subscribers in California, I very well may be subject to California law. I probably am, okay? Don't think that if you're in Rhode Island, Oregon doesn't matter if you got accounts there. Don't think if you're in Maine that Florida doesn't matter because you got accounts there. You're subject to that state's jurisdiction. Why do I tell you this? Because I think there are only 4 states that don't have breach notification laws. And I wouldn't be surprised if we were down to 2 at this point. That's a little old, that data. California and Massachusetts, it shall come as no surprise, have very strict privacy laws, online privacy laws. If you're doing business in either of those states, you need to know what those laws are and comply with them. And the California AG's office has a specific task force that investigates breaches of privacy policies. All right? And they're very active. So state law is another thing you have to worry about. Another thing you got to worry about in this arena is class action lawyers. There are class action lawsuits out there. Some recent data breaches, LinkedIn, Wyndham, Sony, Epsilon. Okay, and then the Barracudas are sort of trolling around to come in and file a class action.
The NSA covered.
For the right retainer, we can find that out, sir. Statistically, 90% of all organizations in the U.S. have experienced some data breach in the past 12 months. 90%. So there's a very good chance that you have experienced, you probably don't even know it, a data breach on your system, on your website, on your network. And everybody thinks, hey, this is just the big guy's concern. Actually, the hackers, if you read the news, they're targeting small to mid-sized businesses. So be careful. Data breach can look like external third-party hacking, but it also can look like a current employee making a mistake, leaving a laptop somewhere, forgetting it, restaurant, car, hotel room, rental car. Okay, we've all seen those stories. That is not something we in the security industry want to get involved with. You do not want to get involved with that sort of situation because we're a security provider, and here we are breaching security protocol. You got to worry about former employees, both in terms of malicious and inadvertent disclosures. Okay, these are all possible data breaches. Why do you care about data breaches? Lawsuits are expensive, remediation is expensive, and damages at the end, a judgment, can be very expensive. You need to figure out, in the event of a data breach, whose law applies. You might be required to notify state AGs. You might be required to notify affected persons. You might be required by law to provide affected persons access to certain services, like credit monitoring, depending upon what information is breached. And also, you're going to have damage to your reputation and ultimately a loss of RMR. Does insurance apply to protect you? Probably not, unless you have cyber liability coverage. A commercial general liability coverage policy will not respond to a data breach. You've got to get cyber policy. So if you don't have a cyber policy, get one ASAP. 3:30, we're cloud's boring. You guys don't. Anybody have any questions? Anybody really want to hear about cloud? Is that, sir?
Question related to the privacy policy. So we use multiple providers, iPhone apps. So for Honeywell,
Well, I think you have to have a privacy policy in place, period. But thank you for getting me to the cloud. So alarm.com is the cloud, all right? And here's the 2 minutes on the cloud. You cannot negotiate decent terms and conditions with the cloud providers because they take almost a draconian approach to liability as we do in our industry. In their industry, they're almost as sensitive as we are about limitation liability, indemnity, that sort of stuff. They are not going to be willing to take on any liability on the cloud. Forget it. Try to negotiate it with them. Won't do it. Won't happen. So what you need to do to protect yourself is make sure that you've protected yourself with your subscriber. In other words, push the risk of loss. It's coming from the cloud provider to you because they're not going to take any responsibility over here. So you now need to transfer it to your subscriber. And you need to make sure that you've dealt with that in your subscriber agreement. Anybody ready to sell their company now? Because that was the whole point of this. Just kidding. Sir?
Are any of the data breach notification requirements, are they written specifically with internet connectivity in mind, or would it apply to someone who has, say, no online presence but lost a hard drive on its way to secure?
The latter, not the former. Yeah. Yeah. Okay.
Okay, so your updated contracts deal with everything from video verification, cloud privacy, or privacy is separate, the privacy policy is separate.
Yes.
Kind of issue.
Yes.
And then data security.
Yes.
Is
Yeah.
it all inclusive?
No. No. Some of them are, some of them aren't. Yeah.
Well, they had a class yesterday about service contracts, and they encourage that you use maybe like a 1-year term versus a 3 or 5 year term like you do on monitoring. And I was thinking about it again earlier with the video and things like that. As a buyer, it gets tricky when you've got 3 or 4 different pieces of paper for the same customer. And it's certainly, frustrating when you're out there selling it to have all these different contracts.
I misunderstood.
But you want to include all the information.
I misunderstood your question. My contract covers monitoring, on-premises services, pretty much every service that you're going to provide. Yes, it's an all-in-one. Yeah, yeah. I don't sell 3 different forms that get you to $1,000. I have one form that's, my form is 575 resi and 575 commercial.
What are you seeing as the biggest mistake or challenge right now? I mean, where is the biggest soft spot for alarm dealers right now?
Whew, that's a tough question. Look, I love video verification. I just love it. I think it's a way to add RMR. The price points are coming down. I'm not pushing anybody, but I know that VideoFide came out with a PIR that's also a camera that's very reasonably priced. Yeah, yeah. I love video verification. I'm thinking of going into business myself.
But to cover that is tricky or not?
No, just need an effective contract. Sir?
Are you aware of any other industries that have a similar risk and liability profile that have been tested for pull-through and shrink wrap contracts? And it feels like those are common in the software world, but this feels like new ground that could be pretty.
Well, the truth of the matter is that the law for the security industry is actually very positive in most states, particularly if you can get New York law to apply. New York law happens to be very good for alarm companies. So I like our law. The truth of the matter is that we don't make law as much as we used to, and I'll tell you why. The big cases, and you usually only get big cases in the alarm world, are brought by insurance companies as what's called subrogees. Subrogation is a doctrine that says an insurance company that pays an insured then steps in the shoes of the insured and can sue a third party to recover its insurance payment. Subrogation has its own bar. There's a subrogation bar. Lawyers who do subrogation work, it can be very profitable. 10 years or so ago, a lot of the subrogation bar got that our clauses were enforceable, and even if they weren't enforceable, they didn't want to spend a lot of money fighting with us about whether or not they were enforceable. So I don't see as many cases as I used to. I also don't do the insurance defense work anymore. So, take that with a grain of salt. But I love our law.
Many old alarm contracts did not have a subrogation
It's my personal mission to stamp each and every one of them out in the United States of America. Waiver of subrogation is a great way to go. It really is helpful. I've won cases on waiver of subrogation. Yeah, it's a great way to go.
Do you have a contact for that video association?
ppvar.org. ppvar.org. Yeah.
PPVAR.
VAR. Yeah.
And do you have one of your cards?
What would I be without a card as a lawyer? Somewhere I do. Hey, thank you very much. I really appreciate it. It was a lot of fun. Yep.